Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall and my co-host today is Anora Wang. Hello, Anora.
Hi, Matthew.
Today's episode is The Future of Enforcement and Compliance, how computational antitrust is used by regulators and companies. We'll be discussing the use of computational methods to automate antitrust procedures and improve antitrust analysis, generally referred to as computational antitrust. Our guest today is Todd Davies. Todd is a PhD candidate in competition law at University College London and a research fellow of the Inclusive Competition Forum. His research asks how competition law can better understand the competitive process with a focus on effective competitive structures. He previously worked for 6 years as a software engineer at Google, mostly in the security and privacy space, so he brings a unique perspective to this issue. Hello, Todd, and welcome to the show.
Thank you so much. It's great to be on here. Welcome to everyone listening. And thank you, Matthew, for doing my disclosures for me.
No problem. You're welcome. We've looked at this issue previously on Our Curious Amalgam, including episode 86 from 2020, when we had as our guest the Chief Data and Technology Insights Officer from the UK competition regulator, the Competition and Markets Authority. But Todd, as I mentioned, brings a different perspective to this issue. So Todd, let's start with what is computational antitrust?
Great question. And I would really recommend going back and listening to that episode as well. So computational antitrust is a subset of computational law, which is broadly speaking using computers to automate legal analysis. And as you would expect, computational antitrust is applying those kind of techniques to antitrust law, or as I would say, competition law. And that includes all sorts of things, basically along the whole lifespan of a case. So from detecting and analyzing anti-competitive practices, helping design or monitor remedies, and from the company side, helping companies improve or automate their compliance. And I think recently the discussion around computational antitrust has focused a lot on authorities, and that makes sense because authorities do have a pretty tough time at the moment. They have, a lot of demands. The economy just gets more complex every year. It gets bigger every year, hopefully. But competition authorities maybe don't get the same boost to their budgets, and so they have to do more with less. So computational antitrust, in a sense, its promise is to help them to respond to a changing economy, both in terms of its scope, but also its complexity, and enforce the law more effectively.
Todd, we're talking about competition authorities around the world, right? And maybe we will go into that quite a bit later. Sounds like there is already widespread adoption by authorities around the world. What are the pros and cons of adoption by these authorities?
Yeah, great question. So there are a lot of competition authorities seem to be using computational antitrust. And a quick shout out to the Computational Antitrust Project. They do a report every year and I think the way it works is they ask competition agencies for essentially how they're using computational antitrust. And then they compile that into a big report that they then publish and put on SSRN. And I think there's usually about 30 agencies come back and say, yes, they're using it. So it's quite widespread. And what are they doing with this? Like, what are the benefits of it to agencies beyond what I said before? Well, the first thing is probably enhanced capabilities. So, doing things that they were already doing before, but quicker is one of them. So you might think about bid rigging, for example. This could be anything from simple statistical techniques, which you might say are econometrics, all the way up to quite advanced machine learning to detect things like suspicious bidding patterns, but also data acquisition. So sometimes that will be automated with computational antitrust techniques. So you could get a computer bot to go and scrape all sorts of documents off of the internet so that you don't have to do that yourself, which might take a lot of time. Relatedly, things like document analysis. So I think this was mentioned on a previous episode of the ABA podcast, and Stefan Hunt from the CMA came on. I think that's the one you were referring to. And he was talking about how the CMA's data unit has taken on lots of data scientists, and they use text mining techniques to be able to extract information from large caches of documents that have been discovered. And then lastly, things like news monitoring. So looking at the news, seeing events that have happened automatically, and then flagging ones that are relevant to the agency. So there's quite a broad variety of different things that you can apply this to, and many of which kind of take a lot of the weight, or in theory take a lot of the weight, from competition authorities, and essentially let them do more stuff with less resource and kind of offloading that. And then also, there's also this potential, maybe a bit of an elusive potential, for competition authorities to share some of the tools they've developed. So in theory, if one competition authority was to develop a tool, they could then give it to another competition authority to use in the same use case. And this could be a source of efficiency gains. We'll see how much that actually happens. But then turning on to some of the cons, or some of the kind of less positive aspects of computational antitrust, I think that the two ones I want to focus on here are the costs and the complexity in terms of agencies. So in terms of the cost, I think if agencies are going to be developing this stuff in-house, it's important to recognize that it's not just about building this software, it's also about maintaining the software. And now, putting my software engineer hat on, that is a difficult undertaking. And this is not me, being a bit of a techno pessimist or something. I'm a massive geek, and I love to code, and I love software. But at the same time, because I am a software engineer, I know that the best code is no code at all. Because if you don't have any code, you don't have to maintain the code. And that's a very well kind of known proverb among software engineers, if you like. And the trouble is that what happens is that you start to develop some software to do some bid rigging or analysis or whatever. And the first 90% of the software is, the development goes well, everything's working. And then the last 10% are like the really difficult bugs, the features that you need to add that were difficult to implement. So you're very tempted to leave it there. And then this happens once, and it happens again, it happens again. And before you know it, you have all the software which mostly works, but all those little 10% have added up and added up and added up. But by this time, you rely on the software. You're depending on it. And so the risk is that you end up depending on software which doesn't quite work how you want it to, and that can end up slowing you down over time. And to avoid that, you have to continually invest in maintaining it, keeping it working well, updating it, etc., etc. So there's this kind of medium to long-term investment that I think agencies need to be aware of when they're doing this. And one solution to this might just be to outsource to third parties and get them to build the tools instead. And it's just a trade-off, essentially. The other thing is complexity. So something we've seen over the past maybe 40 years of competition law is this increasingly heavy reliance on economic evidence, which has changed the law in all sorts of ways. Some of them are good, some of them we can debate. But one thing that it's done is sometimes it can be hard to scrutinize some of this economic evidence if you're not an expert. And it might be difficult to realize or to figure out whether something is illegal without doing some kind of big analysis. And I think there's a risk in my mind that if we end up outsourcing a lot of antitrust analysis to computers, then the same thing might happen. We always need to be able to open that black box and to get a good grasp of what some of the decisions are in here. And we don't want, in my mind, computational techniques to end up being a black box that we can't see. So there's some of the pros and cons that I see in how agencies might be adopting computational antitrust.
Todd, you referred to that Stanford Computational Antitrust annual report. We'll put a link to that. That was a very interesting report, and it picks up several of your points. One additional point I noticed in the report was that it refers to the as a key finding over the last 12 months, and perhaps the most significant finding, is the depth of change within agencies, the evolution of those agencies, and how rapidly this is all happening within them. And in addition, you referred to bid rigging, and they identified in that report that that's the most common specific application. And I guess, interested in your thoughts, but I guess that's probably because it's quite a relatively easy issue for this type of software to pick up on. I guess there's some kind of key facts and points and data points which could easily be identified in that kind of a situation.
Yeah, that makes sense. And I guess with bid rigging, the form of the abuse is quite similar. So you have a bid that's happening, and then somehow the bids are not the genuine bids. So when you're designing a system, you can kind of imagine that is the problem that you're looking for. And like that's how you would see it as a software engineer. Your job is to build a system which can not only like detect those suspicious bids, so to speak, but also maybe discover those bids happening in the first place. So, creating software pipelines that can pull in some of this data from the internet somewhere about what bids are happening, what, et cetera, et cetera. And that's quite a stable, well-defined problem, if you like, for an engineer to solve. Now, if you think about a different kind of competition issue, so let's say an abuse of dominance under Article 102 TFEU, there's an infinite number of ways that a dominant undertaking could abuse its dominance. And all the time, we start to see new kinds of abuse happening. So if you're trying to build some kind of computational antitrust method to essentially detect and analyze these, you may as well, train yourself a lawyer, because, the variety of different abuses that you would get is quite large. So I think that's probably why I would say bid rigging is one of the ones that's getting faster adoption here.
So it sounds like there are more areas where the analysis is more difficult. That's probably somewhere you would say should not be subject to overly outsourced or getting into a black box. And it's a rapidly developing area in the adoption of authorities. What about the other side of the coin? What's the use cases by companies? Are they considering the same pros and cons or facing the same issues in adopting computational antitrust tools?
Yeah, great question. So I think most of the conversation about computational antitrust has been about agencies, has been about how do agencies operationalize this kind of technology. Now, of course, agencies aren't the only people in the world of competition law. There's plenty of people. And companies are huge players in that game, so to speak. And it makes sense that they will also be looking at these kind of tools and looking for how to operationalize them. And I think the question here is one of compliance. Now, I hadn't really seen very much on this up until recently. And I recently wrote a blog post in the Kluwer Competition blog, which is a really great place to write if you're ever interested. Shout out to them. And it was about an interesting emerging example of what you might call, a little bit generously perhaps, proactive compliance on behalf of companies. And this all came about because I went to a law and tech hackathon. If you don't know, a hackathon is essentially where you go somewhere for a weekend and you spend a weekend with a few friends and a crazy idea, and you try and hack that idea into reality. And my idea that weekend was that emails are a key source of evidence in competition law cases, and we see that in all kinds of cases. And sometimes the court will even remark on emails there being so much evidence in electronic format like emails. And companies know this. So companies will quite routinely offer guidance to employees saying, this is how you should communicate internally, because these emails that you're writing to each other could one day end up in a court case. And there's a great Substack blog called Internal Tech Emails, which is quite an entertaining read sometimes, which essentially publishes some of these that have been discovered by big tech CEOs. And the question was, well, if you're a company, it's quite hard to get your employees to follow this advice, because every time you write an email, you don't think of, I got such and such guidance 2 weeks ago, or 2 years ago from HR or whoever. So could off-the-shelf AI models detect potentially risky, inverted commas, emails as they are written? That was the question at the hackathon. And to cut a long story short, it turns out that even stock large language models, generative AI models, are very good at doing this. You can give them a prompt which has examples of this kind of language, explains what kind of issues there could be, etc., etc. And they will reliably detect emails that have some kind of evidence of anti-competitive intent or language, and even pinpoint the sentences which could be removed or even reworded and suggest rewordings to make those emails a little bit less unsafe, shall we say. So an example of that is, instead of saying, we want to maximize the network effects and create a barrier to entry for our competitors, the AI might say, you should kind of say the opposite of that. We want to create a lot of value for our consumers to ensure that we provide a product they love. And it says mostly the same thing, but doesn't quite talk about the harm to competition that some kind of behavior might result in.
So Todd, just in practice, I recommend everyone to read that blog. We'll put a link to it. It's called The Dark Side of Computational Antitrust, when AI is used to evade the law. But Todd, just to understand how that in practice it would work with an off-the-shelf generative AI, would you paste your text into the AI and it would rewrite it, or would it be running over your Outlook or something like that?
Yeah, it's a little bit smoother than copy pasting, because if the employees had to copy paste, they would forget and they wouldn't do it. So the way it would probably work is something like an extension in your browser, like a Chrome extension, for example. And that would work on the page where you're sending emails, so Gmail or the Outlook web app or whatever. And as you're typing the email, it would look at the email, it would take the text, and it would then automatically, and you wouldn't have to do anything, prompt the AI to say, with this prompt saying, you are a AI research assistant, your job is to look for potentially risky emails. Here is the email, suggest some rewordings. And then maybe the AI says everything is fine, in which case nothing happens from the point of view of the employee. But if the AI flags that there is an issue here, that there's some kind of language which could be problematic, then the Chrome extension, before you would send the email, or perhaps while you're drafting the email, would say to the employee, hang on a second, are you sure you want to write it like this? That is the use case, and that's how it will be operationalized. And by off-the-shelf AI models, I mean that these wouldn't be models that are trained specifically to do this. They would be large language models like OpenAI's ChatGPT or Google's Gemini or something like that. But they have a good enough understanding of competition law to be able to do that.
You refer in your blog to a particular startup you identified, which has a presumably paid for product which does this. Would it operate in the same way?
I think so, yeah. So the startup is Lex Verify, and I'm not trying to call them out in any way. But it was very interesting that I went home from the hackathon, and then a few weeks later, somebody told me, they were like, oh, like this thing exists already. So that was the trigger for writing this blog, essentially, to raise awareness of it. And as I understand their product, that is essentially what it does. That it will check emails as they are being written and flag potential concerns, not only for competition law, but it does do competition law, but also other regimes like GDPR, for example.
As you say, it covers other regimes as well. Just to understand, I mean, we'll move on in a moment, but just to understand in practice, maybe you don't know, Todd, but would these tools retain any kind of metadata or something behind the scenes? So if employees were typing inappropriate things, it would, there would be some kind of record, or would it, if you like, just be completely invisible and never appear?
Yeah, I think this is such a fascinating area, because you could build this tool in so many different ways. And I think this is something which is almost like the case everywhere when it comes to software. your imagination is really the limit in terms of how you decide to make these things work. So you could imagine, on the one hand, that the tool could log every single character you write in the email and like essentially save every single draft as it was being written, and only then flag potential issues as the email was being sent. In that case, the evidence could still have been logged, in a sense. Now, there might be a question as to whether an email that was never sent and it was drafted in a particular way and then redrafted before it was sent could be used as evidence. And frankly, I don't know what the answer to some of those questions are. But that's on the one hand. On the other hand, you could have it where nothing is ever logged until the email is sent. So you could draft everything you like, and the AI could run locally on your computer, so it would never be sent to a server somewhere. And it could kind of work with you to write something which is legally quite watertight, and then you could send it. So there's quite a spectrum of different ways to implement that. And towards the end of the blog post, actually, I call out that there is perhaps trade-off here between the private interest of the companies which implement this kind of stuff and the public interest and the ability for competition authorities to enforce competition law in light of the potential for evidence to not be produced in the same way as it is today.
As you say, I guess there are kind of any number of ways it can be set up and run. Do you see any other, beyond monitoring emails, suggesting changes to emails, etc.? Do you see any other particular proactive uses that companies can put to computational antitrust, whether compliance or otherwise?
Yeah, I don't know. I really don't know. I'm sure we will see people coming up with them. But I haven't seen any other ones yet. And yeah, I mean, the thing about AI is it's such a general technology these days. It can really do so many things. So at any point where you might have a compliance question, there is always the potential to integrate AI in there. And yeah, I'm sure we'll see some.
I'm sure that's right. So you referred briefly there, Todd, to kind of a trade-off between the public interest and the interest of companies in compliance. I guess following on from that is the issue of what might competition authorities do in response if this type of product or use case on the company side becomes more common, more ubiquitous, reduces the amount of evidence available, etc. What kind of response might we see from the other side?
Yeah, so I don't think that at this point we need to go for a ban or something. I think that would be very drastic, and we're not there yet. I think these tools are barely operationalized today. I think for now, it's important to raise awareness that these things exist. And in terms of how competition authorities could respond, there's perhaps 3 steps or 3 different things I can think of, which is to integrate this into their horizon scanning, maybe building a little bit off the question that you asked before, trying to figure out how, if possible, to use these tools in a way which is good for the way that the competition law works more broadly, taking a more systemic approach. And thirdly, maybe thinking about, well, is it sensible to rely so heavily on email evidence altogether? And if not, then how might we kind of make up for that evidentiary vacuum, so to speak? So very briefly on those, when competition authorities are doing their horizon scanning, as you said, I think they should be thinking about, well, how else could LLMs be integrated into how companies do their work? And what that might manifest in is competition authorities producing guidance to companies, say, this is how you could and perhaps should be operationalizing LLMs in your compliance or however. And that brings me to my second point, which is, well, how do you make this work in a way that works for competition law? And as we were talking about before, there's so many different ways that you could implement this kind of stuff. And here I want to point to cartel leniency as an example. So let's say I am an employee in a company and I'm organizing a cartel, and I email my competitors and I'm like, oh, the prices are too high, too low. We need to bump the prices up a little bit. This would be something that AI would definitely detect. It's very easy for the AI to detect that. And when I've been testing it, it always does. The question is, well, what does it do? It could let that email be sent, but also forward the email to the legal department of the company, and with a message saying, your employers sent this, here are the leniency guidelines for your jurisdiction. You might want to consider applying for leniency. And that might encourage cartel leniency applications, spur cartel enforcement, and still be commensurate with the private interests of that company itself, because of course, then in applying for leniency, it wouldn't be impacted as much. So I think there's ways to align the public interest with the private interest here. Also, so the blog post was on LinkedIn as well, and a commenter called Rupert, he mentioned that something else that these tools could help with is the promulgation of competition. So competition authorities could encourage them to be developed in such a way as to explain to employees, this is what the law is trying to do. And I think it's difficult when you speak to people, ordinary people, you can't expect them to have a great knowledge of competition law. And it might be that there is an email that they're sending where they accidentally, do end up organizing something or starting to build something which could be anti-competitive. And it might just be that the AI can flag that competition law is a thing, and that's something that they might need to think about as they design their products, as they design their business strategy, et cetera, et cetera. And I think that, although it sounds a bit lily-livered in a sense, I think it really could be an important direction that could go in. And then lastly, in terms of thinking about how to use this technology in a systematically good way, another opportunity might be in remedy design. So it's not unprecedented for authorities, regulators, to have some kind of wiretapping style access to communications of regulated firms. So I'm thinking about for insider trading use cases on trading floors, for example. So it could be that if a company has infringed competition law multiple times, a remedy could involve some kind of competition authority supplied tool that would then look for enforcement questions or enforcement issues automatically within the organization. Now, that's a very, very out there idea, but in terms of horizon scanning, it might be something that competition authorities could explore the feasibility of. And then the last one is, should we rely on email evidence altogether? Because it might just be that maybe email evidence is going to fade away. Maybe we can't stop the rise of this kind of technology. And I think the only way to address that is to think about, well, it's really an academic question and a legal practice question at the end of the day. Like, how can you get enough evidence to enforce your competition laws absent emails? And to some extent, I think that's going to involve us clarifying some of the concepts at the root of what competition law is. Other times it might be developing new methods to be able to prove anti-competitive behavior without having to rely on intent in emails, et cetera, et cetera. But I think it also points to, I think it suggests to us, it's like an early warning that we shouldn't be relying too much on emails. I heard a recent episode of this podcast where somebody was mentioning that killer acquisitions, the way they should be detected should be through email evidence. And I think, that kind of, this whole question shows that kind of strategy is perhaps not very robust, or it will become less and less robust in the future.
Yeah, that's a very interesting issue. Maybe, as you say, AI is coming along rapidly and emails are maybe kind of 20 years out of date, and you need to look at something else going forward. The Stanford Computational Antitrust, the original paper, and I think you quote this in your blog comments about this specific issue, that regulators could struggle to find evidence, could lead to under-enforcement, and computational antitrust should not become a zero-sum game. So I think that is a specific issue that's been highlighted there. I was interested in your comment about remedy design and that intrusive monitoring instead of a monitoring trustee or self-reporting. That would seem quite an interesting issue. And also, I was interested in your comment on whether emails could be forwarded directly to the legal department if they're potentially problematic. I mean, further thought on that perhaps, but it's a bit difficult to see why a company would allow an email to go out that an AI had already identified as problematic, because then you of course have a record of that, in the system, if you like. So I'm not sure quite why a company would want to only alert itself, after an email has gone out and allow it to go.
Yeah, I think, well, again, we get back to the design of how this works again. And I think from a technical point of view, if your aim was to build a system that can then alert the legal department that there is potentially cartel organizing activity happening on email or something, I think any time that you like computerize or like log that fact that there was an email that was being written or that had been written that wasn't sent, then that also might be evidence, just that log, that it might happen, and like that notification to the legal team. So I think it's an interesting question. Maybe if you really wanted to avoid scrutiny, you could do it so that the legal team is alerted that an employee tried to send an email that was then blocked, but it never logs what it was. But yeah, it's a difficult question, and one that I think at the end of the day, if you were a startup trying to operationalize this idea, and I'm sure that startup we talked about is thinking about this, then you would have to seriously address those questions of incentives and also evidentiary questions about what could be used in a court.
Yeah, I mean, we're in early days of this kind of thing, I think, but these are issues which are going to be worked out, aren't they, over time?
Yeah.
What do you see as the key takeaways from this discussion for practicing lawyers and companies?
Yeah, well, I am an academic, so part of me thinks that I'm the least well qualified to answer this question for practicing lawyers. So you should take my thoughts with a pinch of salt. But my first, or the big thing I want to raise here with the whole discussion is that these tools are emerging. That like this is a thing, it's going to be a thing, it's probably going to be more of a thing. So it's on the horizon, so to speak. The second thing that I would say is that just because these tools are beginning to exist doesn't mean in any way that they're going to solve, these questions that they're trying to address. You're not going to be able to ever make an app which is going to, ameliorate your competition law or compliance concerns by doing this kind of thing. It's just not possible. So I think we should be aware that it's happening. We shouldn't buy into the hype that it might be becoming a big thing. And third, I think if people are looking to operationalize this kind of thing, I think that they need to think very carefully about the questions of evidence. And here I would point people to some of the recent Google cases, Google antitrust cases that have been happening, where the US judges have been a little bit questioning some of Google's practices with regards to it auto-deleting the instant messages that people would send within the company. So essentially what would happen is you would send an instant message and the default setting would be that those instant messages would disappear. They would be deleted after a day or a week, or I forgot how long. And essentially the issue here is that, well, you can write whatever you like, but it's just not going to stay. So I think these questions need to be thought about in depth before these kind of tools are implemented.
Absolutely. As you say, ephemeral messaging is a big issue, and I know there's certainly something that the regulators are worried about and flag up regularly. Todd, so before we finish, we like to move on to a couple of personal questions, as you know. So firstly, something we ask all our guests, could you please tell us something interesting or unusual about yourself that we would not know from just working with you, or if you like, researching with you at UCL?
Yeah, so one of my hobbies is I like to go cold swimming, which is only really a winter hobby, to be honest. And there's a wonderful outdoor swimming pool near me in Hampstead Heath in North London. And it's open air and it's not heated. So in the winter, it's about the same temperature as the air. And on Friday mornings at 7 a.m., some of my friends and I, we jump in the pool, we spend about as long as we can in there, and then we go in the sauna, which is nearby, and then we cycle in the sauna in the pool a few times. And I have to say, it's the highlight of my week. It's so fun. And if you work with me, you probably find out that about me quite quickly, to be honest, because I rave about it.
Okay, so something to be recommended. No wetsuits, I assume, there. You're jumping in and out of the...
Well, a recent addition is I recently got a wet gloves and wet socks, which really helps because those bits are the bits that hurt the most.
Yeah, that sounds reasonable.
And now it's time for the Curious Hat!
So, Todd, as you know, we ask you to choose a number between 1 and 20, and then we select the question based on that number.
Oh, 12, please.
So number 12 is, could you let us know what book you are currently reading and whether you would recommend it to our listeners?
Yeah, I'm currently reading Orwell's Roses by Rebecca Solnit. And what I like about it is it combines two of my favorite authors, George Orwell, who's increasingly relevant today, and Rebecca Solnit, who is a really, really great contemporary author. She writes all sorts about everything. And essentially what the book is about is Orwell's life, in a sense, but his love of gardening in particular, and how this was a huge part of his life. It's not something that a lot of people know about, and how he planted this rose bush in his garden in the 30s at some point, and it's still there today. You can go and see this rose bush that he was tending to and he was writing about in his journals. And then from that, Solnit then goes into all sorts of meandering anecdotes, which are quite fun as bedtime reading. So yeah, it's a good book.
And where is this garden?
Yeah, so I think that garden it's in the home county somewhere in the UK. I've forgotten which one. But Orwell also spent a lot of time on the Scottish island of Jura, where he also had a quite a big, like, small holding setup.
Yeah, I think that's right. He's famously spent a lot of time there, didn't he? Well, that looks like an interesting book to look up, so I'm going to do that myself. But Todd, this has been a great discussion, cutting edge area. You've brought your expertise and your research focus to our listeners. So thank you very much for that. And thank you, everybody, for listening.
Thanks for having me on.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.